Ladies and gentlemen, please stand for the arrival of His Lordship, the Honourable Mr. Mario Michel, Chief Justice. Please remain standing for the arrival of the Honourable Dr. Terence Drew, Prime Minister of St. Kitts and Nevis. And I'd like to announce the arrival of Her Excellency Dame Marcella Liburd, GCMG, JP, Governor General of St. Kitts and Nevis. And we now ask that you remain standing for the playing of the national anthem by Mr. Inoite Inanga. Please remain standing for the prayer by the Ombudsman, Bishop Cyprian Williams.
Let us pray. Heavenly Father, we come to you this evening with humble hearts, seeking your guidance as we embark on this public education lecture series. We ask for your wisdom. Lead us through this discussion. Maybe we be open, fair, and clear. Almighty God, we thank you for the gift of justice and the rule of law, and for the wise and dedicated individuals who uphold these principles. This evening, we ask your blessings upon this proceeding. Bless everything that would be said and done. And at the end, you receive the praise, the glory, and the honor. In Jesus' name we ask. Amen.
You may be seated. Her Excellency, Dame Marcella Liburd, GCMG, JP, Governor General of St. Kitts and Nevis, Honorable Dr. Terence Drew, Prime Minister of St. Kitts and Nevis, His Lordship, the Honorable Mr. Mario Michel, Chief Justice of the Eastern Caribbean Supreme Court, the Honorable Justices of Appeal of the Eastern Caribbean Supreme Court, resident High Court judges, His Lordship, the Honorable Justice Ian Morley, Her Ladyship, the Honorable Justice Tamara Gill, and other High Court judges and masters of the Eastern Caribbean Supreme Court, Honorable Mr. Justice Adrian Saunders, President of the Caribbean Court of Justice and judges of the Caribbean Court of Justice, Honorable heads of the judiciaries of the Caribbean region, the Right Honorable Dame Janice Pereira, retired Chief Justice, the Right Honorable Sir Charles Michael Dennis Byron, former President of the Caribbean Court of Justice and former Chief Justice of the Eastern Caribbean Supreme Court, retired judges of the Eastern Caribbean Supreme Court, the Honorable Lanine Blanchette, Speaker of the National Assembly, the Honorable members of the Federal Cabinet of St. Kitts and Nevis and their spouses, our featured speaker, the Honorable Garth Wilkin, Attorney General of St. Kitts and Nevis, and other Attorney Generals of each of the OECS member states and territories. Ms. Rhonda Nisbet Brown, Magistrate of St. Kitts and Nevis, and all chief and senior magistrates and magistrates of the OECS member states and territories. Mrs. Gretes Gordon Hazel, Assistant Director of Public Prosecutions of St. Kitts and Nevis, and other directors of public prosecutions of each of the OECS member states and territories. Mrs. Simone Boleyn Thompson, Solicitor General of St. Kitts and Nevis, and other Solicitor Generals of each of the OECS member states and territories. Mrs. Michelle John Theobald's Chief Registrar, and Ms. Daniela Chambers, Deputy Chief Registrar of the Eastern Caribbean Supreme Court, Mr. Gregory Gerard, Court Administrator, and Mr. Francis Letang, Deputy Court Administrator, Mrs. Eshe Hendrickson Johnson, Deputy Registrar, and Ms. Melissa Fleming, Assistant Registrar, and other registrars and deputy registrars of the OECS member states and territories, the Ombudsman, Bishop Cyprian Williams, and Law Commissioner Ms. Josephine Malalu, Mr. Dwight Lay, General Counsel of the OECS Commission, Ms. Jean Dyer, President of the OECS Bar Association, Presidents of the constituent bar associations in each of the OECS member states and territories, Mr. James Sutton, Commissioner of Police in St. Kitts and Nevis, Permanent Secretary in the Ministry of Justice and Legal Affairs, Ms. Narissa Williams, members of the Inner and Outer Bar attending in person and virtually, staff of the court's headquarters and the St. Kitts and Nevis High Court offices and court offices in each of the OECS member states and territories, students, distinguished guests, members of the media, members of civil society, non-governmental organizations, and a special good evening to our online community throughout the OECS who are here with us via YouTube and Zoom and other platforms. I wish to welcome you to this evening's proceedings. My name is Nisha Maratan-Mack, and I am the Registrar of the High Court in St. Kitts and Nevis. And it is my distinct pleasure to welcome you to this evening's inaugural public lecture. We are pleased that His Lordship has chosen St. Kitts and Nevis to host the first in the lecture series. And as Kittitians, we know St. Kitts and Nevis is not afraid to be first. We love to be first. So we thank you, Chief Justice, for choosing this jurisdiction. We are also honored by your presence, and I would like to extend a special welcome to His Lordship, the Honorable Chief Justice, Mr. Mario Michel, and our esteemed guest speaker, the Honorable Attorney General, who has graciously accepted to present to us under the theme, Justice Without Borders, the Legal Practitioner's Perspective and the ECSC Reality. This lecture series aims to foster a deeper understanding of the critical role of the court in our communities and to engage with the wider public through thought-provoking conversations that shape both the legal profession and society at large. Today's discussions promise to be no exception as we explore justice without borders. I also want to take a moment to thank and acknowledge the efforts of the headquarters in St. Lucia for undertaking this task of having these public education series. It is one of many programs that are a part of the portfolio, and we wish to thank them for this initiative. So without further ado, I wish to start this evening's program, and we wish to welcome the Honorable Prime Minister to bring the official welcome remarks. Thank you.
Good evening to all. Let me, of course, thank the Master of Ceremonies for such a wonderful order of precedence that she pronounced just now, and I don't dare try to repeat it. However, allow me to recognize a few persons here, Her Excellency Dame Marcella Liebert, who herself is a practicing lawyer, or was, right? Let me, of course, also recognize His Lordship, the Honorable Mr. Mario Michel, Chief Justice, acting, and also to recognize others from the legal profession, the High Court, also especially, forgive me, to just recognize our presenter this evening, the Honorable Garth Wilkin, who is the Attorney General of St. Kitts and Nevis, who has been working tirelessly hard to set our country on good footing when it comes to the laws. So he accepting to be the first is in keeping with his spirit, the spirit of course, being, as we say in St. Kitts, we are tallow. So, Attorney General, congratulations. I want to say that listening to what the topic is tonight, it really struck me hearing it for, I think, the first time. And a quote resonates with me since I was young. And I think you might know who would have said these words. The ark of the moral universe is long, but it bends towards justice. The arc of the moral universe is long, but it bends towards justice. I think in that quote that we know would have been uttered by Martin Luther King really sums it up, that justice really knows no border. Not even the world as we know it is a border for justice. Justice exists throughout the universe. I also had the opportunity to read a bit of past Supreme Court judge, Court Breyer. I think he had property in Nevis, or has property in Nevis. And on leaving the Supreme Court of the United States of America, he gave a lecture. His lecture centered around the rule of law. And his argument was, and I think he convinced me, that without the rule of law, you really cannot have democracy. That is profound. That is deep as it is true. And so it is critically important, as much as I think that being a doctor is important, that without the rule of law, it would be so difficult even to practice the medical profession. So I submit tonight that maybe in being convinced by that, I might submit that even for tonight, I concede that the legal profession has a little bit of edge. And so I want to say that this is critically important, that we do understand what the rule of law is and how critically important it is for all of us. I really want to stress the point as I welcome all of us to this lecture series and the critical nature of a lecture series like this, because I think it has to be reinforced in all of us, whether we know it or not, that the legal profession, the laws that we abide by, the laws that we strive to establish and those that we argue about, that at the end of the day, the most critical thing is that we are governed by the principle of the rule of law. Without tarrying long tonight in welcoming all of you, I agree with the theme, not because it is going to be spoken on by our esteemed Attorney General, but the words of Martin Luther King, since I was a boy, resonated with me. For the youth who are here, I especially welcome you. For us to remember two fundamental things. The arc of the moral universe is long and it bends towards justice. So the very foundation of the universe is based on just laws. Secondly, no democracy, no modern country, no thriving country can really exist if the rule of law does not exist. And I'll keep my mind open to listen to this lecture, and I invite all of us to do the same thing as the Attorney General, our esteemed Attorney General, venture into this topic and further convince me that yes, the laws are the most important, the rule of law is fundamental, and maybe the legal profession has an edge. Thank you very much.
Thank you, Honourable Prime Minister. And we'll now like to welcome His Lordship, the Honourable Mario Michel, Chief Justice, acting, to bring brief remarks.
Thank you, Madam Chair. Her Excellency, the Governor General, Dame Marcella A. Liburd, Honorable Dr. Terence Drew, Prime Minister of St. Kitts and Nevis, and if the protocol that was given to me is to be taken seriously, I take it that that charming lady next to Dr. Drew is Mrs. Drew, or is that... I see. So I was misled by the... Resident High Court judges, His Lordship, the Honourable Justice Ian Morley, and Her Ladyship, the Honourable Justice Tamara Gill, Honourable Lenine Blanchette, Speaker of the National Assembly, Honourable members of the Cabinet and Parliament of St. Kitts and Nevis, Attorney General and Minister for Justice and Legal Affairs, Senator Garth Wilkin, Mrs. Simone Bullen Thompson, Solicitor General, Mrs. Michelle John Tibbles, Chief Registrar of the Eastern Caribbean Supreme Court, Mr. Gregory Gerard, Court Administrator of the Eastern Caribbean Supreme Court, Acting Registrar of the High Court, Ms. Nisharma Ratan Mack, Permanent Secretary in the Ministry of Justice and Legal Affairs, Ms. Narissa Williams, King's Counsels, Mr. Anthony Ross, Mr. Delano Bart, Mr. Anthony Gonzalez, and Mr. Damian Kelsick, other Attorneys General, other distinguished persons present here this evening, distinguished serving and retired justices at all levels of the court system in the region, and all of the other distinguished guests who have joined us on virtual platforms this evening, other virtual attendees, students, members of the media, ladies and gentlemen. Madam Chair, permit me to commence my brief remarks by expressing my immense appreciation and that of the Eastern Caribbean Supreme Court as a whole for the presence this evening in person of Her Excellency, the Governor General, the Honourable Prime Minister, and other members of the Cabinet and the National Assembly of the Federation of St. Christopher and Nevis. Permit me too to express my thanks to the Prime Minister for his words of welcome and encouragement. Madam Chair, the very strong signal which these manifestations of support give and send enables us to better undertake the public education program on which we have embarked. Because without the support of the executive and legislative branches of the governments of the countries which we serve, the Eastern Caribbean Supreme Court, which is the third branch of the governments, will not have the bandwidth to reach the publics whose interests and attention we are endeavoring to obtain and maintain. Madam Chair, the raison d'etre for the public education program, which we began exactly 2 months ago, is to communicate with the people of the states and territories served by the Eastern Caribbean Supreme Court and to educate them about the court as an institution and about the court system as a whole in the states and territories. You may be alarmed, Madam Chair, to hear some of the utterances of people at all levels in our countries, speaking, whether from the street corners or the parliament chambers, about our court and the court system in our islands in terms of the lack of awareness that these utterances may sometimes betray. To correct this lack of awareness, we have embarked on a public education program comprising several components. The first component has been ongoing since September, which is the conversations with the students at the major national tertiary level institutions in the member countries of the Eastern Caribbean Supreme Court. I have since September addressed students at the community colleges in Dominica, Antigua and Barbuda, Anguilla, and St. Lucia. I will be addressing students of the Clarence Fitzroy Bryant Community College tomorrow. Early next month, I will be addressing the students of the Montserrat Community College. And by January, I hope to address the students of the community colleges in St. Vincent and the Grenadines, Grenada, and the British Virgin Islands to complete this component of the public education program, dialoguing face-to-face with the students whom we expect in due course will be leaders in the economic, social, and political spheres in our countries. These interactions with the students have been very successful and have revealed both the need for and the thirst for such activities. Another of the major components of the public education program commences this evening with the first installment of the lecture series which we propose to undertake. This lecture series aims to target leaders in government and civil society and members of the public in general with a view to broadening and deepening understanding of law and legal systems in contemporary society. We have selected the topic of, quote, Justice Without Borders, the Legal Practitioner's Perspective and the ECS Reality, end of quote, because we believe that it speaks to a significant feature in the rapidly changing legal landscape with which at least some of us in the Eastern Caribbean may not be, but must now be familiar. We have selected Senator Wilkins to deliver this first lecture because we view him as being perfectly perched somewhere in the middle of the newer and older leaders on that legal landscape. He had been in active private practice at the bar in St. Kitts and Nevis for about 12 years. He served as president of the local bar association at a fairly young age and now serves as the Attorney General of his country. Those of us who have observed Senator Wilkins over the years, in my case from the Court of Appeal bench, have also seen him as someone who can communicate effectively the sort of messages that we want to convey to the publics which we serve. Someone who can, in the present, speak the language of the future with full consciousness of that which has passed. We are confident that Senator Wilkin will kick off this lecture series impressively and that we can thereafter continue our public education program with lectures of a like quality throughout the member states and territories of the Eastern Caribbean Supreme Court. Madam Chair, there is one other significant component of the public education program which has commenced, though not yet rolled out publicly. That is the conversations with the Chief Justice, which will be broadcasted on national radio and television stations and other media houses throughout the states and territories. I have already done a very extensive interview with a media professional in St. Lucia, which interview is being packaged in smaller units for broadcast within the next few weeks. There are other components of the public education program which are being prepared for rollout shortly, or in some cases are still on the notional drawing board. But I shall not speak about them now, because this evening is about the lecture series and about the first lecture to be delivered by the distinguished Attorney General of St. Kitts and Nevis. I shall therefore end my brief remarks here and await the address of the Honourable Attorney General. I thank you.
Thank you, Honourable Chief Justice. And next, we have a treat of a group of young men called the Brotherhood, who will do a cultural presentation for us this evening. Let's welcome them. Okay. Give it up for the Brotherhood Drummers. And this is a group of young men. As you can see, they tell me they have 3 females, but it's mostly men. And a young man started this group, and he wanted to start a drumming school. And so you can enroll, if anyone wants to enroll their children, they take them from the age of 5, and that is what they have produced. So we have to give it up to the youth of the Federation of St. Kitts and Nevis. And now we'd like to invite Ms. Azaria Amrit, a 6th form student who will introduce our featured speaker for this evening.
Good evening. Allow me to adopt the established protocol. Senator, the Honourable Mr. Garth L. Wilkin, Attorney General and Minister of Justice and Legal Affairs of the Federation of St. Kitts and Nevis, was born in St. Kitts and Nevis and received his early education in Antigua, Barbados, and St. Kitts. In fact, he is a proud graduate of the Clarence Fitzroy Bryant College. The Honourable Mr. Wilkin was admitted to the practice of law in St. Kitts and Nevis, Antigua, Barbuda, Anguilla, and Montserrat, where he practiced both the civil and criminal bars. At the criminal bar, the Honourable Mr. Wilkin served as a prosecutor. He holds a Bachelor of Science in Civil Engineering from Virginia Tech, a Bachelor of Law from the University of the West Indies, Cave Hill, and a Legal Education Certificate from the Norman Manley College Law School, where he graduated as a member of the Principal's Honor Roll. Immediately before his appointment as Senator, Attorney General, and Minister of Justice and Legal Affairs of St. Kitts and Nevis, the Honourable Mr. Wilkin served as the President of the St. Kitts and Nevis Bar Association. We now welcome Senator, the Honourable Mr. Garth L. Wilkin.
Madam Chair, with your leave, I beg to adopt the protocol already established, although I wish to acknowledge the presence of Her Excellency, Dame Marcella Liebert, Honourable Prime Minister, Dr. Terence Drew, Honourable Cabinet colleagues, Honourable Marsha Henderson, Honourable Iseline Phillip, the Cabinet Secretary, Dr. Marcus Natter, the Honourable Chief Justice, Mario Michel, Honourable Speaker of the National Assembly, Ms. Lanine Blanchett, Honourable Mr. Justice Morlier and Madam Justice Gill, Honourable Judges of the Eastern Caribbean Supreme Court, Magistrate Nisbet Brown, Learned King's Counsel, my learned friends, the hard-working lawyers and staff of the AGO, the Ministry, and the registries in St. Kitts and Nevis, ladies and gentlemen here in St. Kitts listening, and those listening via the internet, the students of my alma mater, the Clarence Fitzroy Bryant College, and other students, including Azaria, who is my cousin, and last but not least, my lovely wife. Good evening, all. When the court office contacted me a few weeks ago with the Chief Justice's invitation to deliver the first lecture in the Eastern Caribbean Supreme Court lecture series, I must confess, my initial reaction was one of excitement. But then the real challenge emerged, the theme, justice without borders, the legal practitioner's perspective and the ECSC reality. As I sat with this notion, my mind immediately began to race, contemplating how to approach such a vast topic, one that questions the very essence of justice in a rapidly changing world. However, it was when I reached to the end of the email that my thoughts crystallized. The Chief Justice expressly wished for me to focus this lecture on the evolving role of the court in the future. Interestingly enough, this is a topic that has preoccupied my thoughts throughout 2024. Earlier this year, I attended 2 conferences that in their very different ways painted a picture of how artificial intelligence, AI, will transform not only the legal profession, but society at large. One from the perspective of the legal profession, and the other from the viewpoint of central bankers. It became clear to me that the conversation I would be having today is not just with the immediate stakeholders of the Eastern Caribbean Supreme Court, but with all of us who hold a vested interest in the future of justice in our region: policymakers, legal practitioners, and the public. And so, I invite you all, my friends, colleagues, and jurists, to open your minds for a brief moment to explore the limitless possibilities of innovation. What if we were to reimagine how we do justice and begin to prepare for the next phase of adaptation and re-engineering of our court to meet the demands of our 680,000 residents scattered across our tiny but mighty sub-region? Let us kick off this thought experiment with two essential questions. Chief Justice, is a court a place or a service? Two, do people with disputes need lawyers, or do they need resolution? These questions sit at the very heart of what we, as legal professionals, do, and more importantly, what role the court should play in the 21st century. Yes, the court is an institution, a place in the traditional sense. In fact, this court is made up of a group of places across the Eastern Caribbean where individuals go to resolve disputes. But it is so much more than that. A dynamic service, one that provides accessible, fair, and timely solutions. Imagine, if you will, that the courthouses and registries were to close tomorrow. Would justice cease to flow? Absolutely not. It can and will continue in a digital age, unshackled from physical barriers and borders. 40 years ago, a courthouse closing meant justice grinding to a halt. Now, the physical space of the court has become secondary to the service it provides. What if, in the near future, justice could be dispensed without the need for a human judge? That is a possibility we must prepare for. And to the second question, do people need lawyers? The answer is, I suggest, no. What people truly need is resolution to their disputes and advice on how best to reach that resolution. For over 9 centuries, the modern path to resolving disputes has been through the courts, with lawyers serving as agents of that resolution. But what if, in the not-so-distant future, that resolution could occur without a human lawyer? Our beloved Eastern Caribbean Supreme Court is unique. It spans the borders of 9 OECS member states, making it truly borderless in the legal sense. But as we know, borders are not just geographical lines. They are the limits of our thinking, the boundaries we impose based on convention, tradition, and history. The questions I have posed challenge us to look beyond those boundaries and consider the future of justice without borders. Justice that is not constrained by outdated methods and assumptions. With technology, particularly AI, revolutionizing every sector, including law, another question arises. Can the court adapt quickly enough to serve as a model of innovation and accessibility? I contend that not only can it, but it must. In this lecture, I will explore how generative artificial intelligence is poised to radically transform the legal landscape in the Eastern Caribbean. I will discuss why legal practitioners and judges should embrace the infinite possibilities of this next industrial revolution fueled by AI, and how the court can strategically harness this technology to enhance both access to and the affordability of justice. Ultimately, I propose that the court commit to a forward-thinking 10-year plan to embrace AI, ensuring its integration is done responsibly and strategically. As a bonus, I have a surprise announcement to share before I conclude. Not even the Honourable Prime Minister is aware of this. Therefore, lend me not just your ears, but your minds for just a few minutes. And just know that when I say I won't be long, my benchmark for long is the Prime Minister's 5.5-hour speech in Parliament in October 2022. No need to worry. Artificial intelligence is a disruptor. Disruption is when a new product or service changes an industry by performing better than existing options, often at a lower cost. Think of the early 19th century Industrial Revolution, a period of technological and scientific development that transformed the world's economy from agrarian to industrial. The Industrial Revolution introduced new machines and techniques that allow goods to be mass-produced in factories rather than crafted by hand. 2 centuries later, the world is tasked with utilizing a tool of which none of us knows its full potential: artificial intelligence. In particular, generative AI represents more than a tool. It is an advanced answer engine capable of processing and synthesizing vast data to support decision-making. Its applications in law include drafting legal documents, analyzing precedents, and aiding in case outcome predictions. During the Commonwealth Law Ministers' meeting in February this year, Professor Richard Susskind, an Oxford professor and IT advisor to the Lord Chief Justice of England and Wales, highlighted the transformative potential of AI in justice. He noted that technology and AI are taking on tasks we used to think required human intelligence. AI can analyze case files, identify patterns, and even predict outcomes, tasks once limited to seasoned legal professionals. Susskind envisions a future where AI doesn't just assist, it empowers citizens by allowing them to understand and enforce their entitlements. He suggests that by the 2030s, not far away, AI will play a central role in enabling individuals to access justice independently, giving rise to a new era of DIY justice. Justice Morley, I know you do not partake in YouTube and TikTok, and for those who are like you, DIY justice means do-it-yourself justice. As Susskind noted, generative AI can summarize complex legal arguments, simulate potential case outcomes, and enhance early neutral evaluations, tasks once reserved for seasoned jurists. This is why AI is considered the next industrial revolution, a hugely disruptive technology. Previous industrial revolutions have occurred when hugely disruptive technologies were introduced and, here is the key, swiftly adopted, leading to widespread changes in the way we live and work. To understand how the court can evolve and utilize generative AI, we must start by defining justice. Justice is far more than rulings, judgments, or even resolutions. Justice is a service commitment to fairness, equity, and integrity. It's a process, a goal, and a fundamental principle guiding the court's mission to serve the people of the Eastern Caribbean. Justice manifests in several forms, each representing a unique facet of fairness and accessibility. Let's delve into these forms to understand how they relate to the court and how AI might play a transformative role in each. At its core, substantive justice is about fair decision-making, ensuring that each case is judged on its own merits, facts, and applicable laws. This is the heart of any judicial system: unbiased, informed, and just decisions. The court embodies this through the diligent work of judges and conjunctively magistrates who consider evidence, weigh arguments, and apply the law with integrity. Generative AI could analyze extensive data sets of past cases, highlighting relevant precedents and patterns, and to support judges and magistrates in making informed decisions. As Professor Susskind said during his presentation on the future of courts, AI can predict outcomes based on prior data, assisting judges by offering valuable insights that enhance consistency and reduce discrepancies in judgments. This technology doesn't replace human judgment, but complements it by providing data-driven context. Procedural justice ensures that the judicial process is transparent, equitable, and respectful of all parties. This builds trust by ensuring that each individual has an opportunity to be heard and that rules are applied consistently. AI can streamline procedural tasks, from automating filings to scheduling hearings, thus expediting processes and reducing administrative burdens. Susskind envisions an online court system where procedures such as case filing, communication with the court, and document submissions are digitized and automated. This model could be adapted for the court to improve procedural efficiency and make justice more accessible. Open justice emphasizes that justice must not only be done, but must be seen to be done, reflecting the importance of transparency for public trust. The court has made strides in enhancing transparency through measures such as live streaming hearings and publishing judgments. What AI could do is play a role by automating the publishing and summarizing of court decisions, making complex rulings understandable to the public. AI-driven platforms could generate concise summaries of lengthy legal text, thus broadening the accessibility of legal outcomes. Technology can help demystify the court process and make it more intelligible to non-lawyers. Distributive justice ensures that everyone, regardless of their background, has access to the legal system. The court serves a diverse population across multiple territories, but economic and geographic barriers can still limit access to the court. AI-powered legal assistance can provide basic guidance to those who might otherwise be unable to afford representation. These tools can answer common legal questions, explain rights, and suggest initial courses of action. Such tools could be a significant step toward democratizing access to justice by empowering self-represented litigants to navigate the legal system more effectively. Proportionate justice focuses on ensuring that legal outcomes are balanced relative to the offense or dispute. This is particularly crucial in criminal cases where sentencing disparities can have significant consequences. AI can assist by analyzing sentencing data and suggesting proportionate penalties that align with regional and historical trends. This promotes fairness and consistency across cases, supporting judges with evidence-based recommendations. For justice to be effective, its rulings must be enforceable. This reinforces trust in the institution. AI systems can track compliance with court orders, providing automated updates and ensuring accountability. By monitoring enforcement efficiently, AI could help ensure that justice is not only served, but upheld. And sustainable justice aims to create a judicial system that is adaptable and prepared for future challenges. The court has shown resilience by embracing innovations such as the e-litigation portal and video link technology. AI-driven predictive analytics could assist the court in anticipating trends and allocating resources effectively. Potentially, we could have online courts where evidence and arguments are submitted digitally and decisions are provided without a live hearing. This illustrates how AI can enable more sustainable, flexible operations. How then do we merge AI and justice in the Eastern Caribbean? The court stands to gain immensely by incorporating AI thoughtfully, using it to bolster each form of justice and make legal services more accessible, equitable, and efficient. Generative AI presents numerous opportunities for the court to enhance justice delivery. Below are specific applications of AI that could transform how justice is delivered across the Eastern Caribbean. These recommendations, I posit, are the low-hanging fruit. Early neutral evaluation. Imagine an AI-powered tool available to every citizen and resident in the OECS member states, providing initial guidance on the potential outcome of a dispute before they knock on a law office door or file a claim. This tool could evaluate facts, compare them with similar cases, and predict the likely outcome, helping individuals make informed decisions about whether to take another step towards dispute resolution. This form of early neutral evaluation would reduce the number of cases that proceed to full litigation, easing the court's workload and providing individuals with realistic expectations. It could also be used at various litigation stages, encouraging settlement and reducing unnecessary trials. Early neutral evaluation, or ENE, operational in this court by the name of Judicial Settlement Conferences, serves as an ADR mechanism where parties receive a non-binding assessment of their case's merits from an impartial expert. The primary goal is to provide an early, frank, and thoughtful assessment that helps parties gauge the strength of their positions and facilitates settlement discussions. Benefits of ENE include providing a quote-unquote reality check for both clients and lawyers, reducing time and costs, focusing the dispute on key issues, and promoting early settlements. If you'd allow me to sidestep briefly, because I have a passion about ENE, as in 2008, my UWI Cavell Law School ADR course paper was on early neutral evaluation. A topic I addressed in that paper was the forces for and against ENE in St. Kitts and Nevis and the broader Caribbean. I cited Sir David Simmons, former Chief Justice and Attorney General of Barbados, who around that time had predicted radical changes in the culture and traditions of the legal practice within the Commonwealth Caribbean. And that was, by my math, I believe, it was 16 years ago. I argue that whilst this change is currently evolving, most jurisdictions have yet to embrace the newer forms of ADR. ENE has simply not found its place yet in the regional judicial systems. Legislation has mainly referred to mediation and arbitration, leaving processes like ENE having to find a back door into the legal system. Therefore, although the judicial and legislative tone suggests a movement towards more efficient legal systems, there are no specific mechanisms in place to authorize the use of ENE, similar to the comprehensive UK Civil Procedures Rules 1999 and the US Civil Justice Reform Act 1990. Regional parliaments would have to intervene and create such avenues for its implementation, following the suggestions from the bench and ENE visionaries such as Justice Wayne Brazil in California. Also being a natural supplement to case management conferences, which at that time had been expressly embraced in Jamaica and Trinidad and Tobago. ENE should, this is my 16 years ago self, garner across the board support. However, the courts need the authority to fashion a more efficient case organization technique, of which ENE is clearly a modern option, end quote. I am pleased that 16 years later, 15 years later actually, after that paper, this court saw it fit to introduce ENE by way of the Judicial Settlement Conferences in July 2023. Now back to the topic at hand. Generative AI can revolutionize ENE by automating the preliminary analysis of case documents and synthesizing past relevant cases. This would equip evaluators with instant, data-driven insights and bolster their ability to provide well-founded evaluation. Moreover, AI-powered platforms can provide litigants with preliminary evaluations even before engaging in formal E&E, empowering them to make informed decisions on whether to proceed to court. As Susskind pointed out, AI's capacity to predict outcomes and highlight pivotal evidence can expedite pretrial resolution, reducing the caseload on courts and fostering efficient dispute management. Chief Justice, an early neutral evaluation app will only be effective if the trust capital of the court is attached to it. Therefore, an effective generative AI E&E solution must originate from the court. I therefore implore you to add it to the administrative agenda. Over the past 2 decades in particular, the court has sought ways to focus on truly contentious and complex issues, while resolving the rudimentary matters by way of alternative dispute mechanisms, such as court-connected mediation. However, I posit that the most efficient pathway to that goal is to utilize generative AI to develop a bespoke digital tool in the pockets of most of our 680,000 residents, which can empower them to make informed decisions on whether to proceed to court or not. Some of my learned friends may not like what I will say now, but it's a fact. Too many cases are making it into our system because unscrupulous lawyers want to generate fees. The ethics of our profession is being eroded, not completely, but a few bad apples are spoiling the bunch. Because of that greed, clients are not being advised accurately. They are being advised biasedly. While generative AI will never solve that societal ethical issue, it can provide the tools to clients to get a second opinion, be more informed, and potentially save their hard-earned money in the process. The court is a service provider of justice. The aggrieved resident is a person in need of justice. An early neutral evaluation generative AI tool can revolutionize litigation by providing early accurate information to a wide cross-section of people in language they can easily understand, to assist them in making decisions, thereby expediting pretrial resolution, reducing the caseload on the courts, and fostering efficient dispute management. Less cases in the system means human judges have more time to focus their energies on complex matters, which leads to more efficiency, which leads to a better justice system. That, I believe, is the first low-hanging fruit for incorporating AI to make legal services more accessible, affordable, equitable, and efficient. Consistency and fairness are paramount in sentencing, particularly across diverse jurisdictions within the OECS. Generative AI could provide data-driven guidance for judges by analyzing vast data sets of past cases to identify common sentencing patterns, ensuring that decisions align with the court's sentencing guidelines, while accounting for the unique nuances of each case. AI can present judges with insights on similar cases and sentences across the region, offering a comparative perspective that would otherwise take extensive research. This guidance could help maintain consistency and fairness, helping to reduce disparities in sentencing across our jurisdictions. AI could also help identify any emerging trends in sentencing disparities, alerting the court to inconsistencies and prompting periodic reviews of the guidelines. Importantly, AI would serve as an assistant to judges, not a replacement. Don't worry, Justice Morley. By providing a comprehensive data-backed analysis of prior judgments, AI can support balanced and proportional sentencing that reflects both precedent and the specific details of each case. In this way, AI empowers judges to deliver more informed and equitable outcomes. Many cases that come before the court involve low-value disputes, which often do not warrant the full weight of court resources. AI could transform the resolution of these minor disputes by providing quick, affordable, and streamlined solutions. Through AI-driven dispute resolution platforms, parties could submit their claims and evidence online, receiving fast preliminary assessments or mediated settlements from AI without engaging in protracted litigation. Generative AI could also categorize these cases, assessing their complexity and value, and recommend whether they should proceed to a higher level of judicial review. Initially, this could be an optional step, but as the system matures, AI-based resolution could become the standard first step for minimal value claims. Appeals would still be available to a magistrate or judge, ensuring that parties retain access to traditional justice mechanisms. This approach not only preserves judicial resources for more complex cases, but also ensures that every claim, regardless of size, receives timely and appropriate attention. While generative AI offers transformative potential, it is designed to complement, not replace, the role of legal professionals. Lawyers bring critical human elements to their work: empathy, advocacy, and nuanced judgment that AI cannot replicate. AI's primary role here is to streamline and enhance legal work, freeing attorneys from repetitive tasks and enabling them to focus on complex, human-centered aspects of their cases. AI can assist lawyers in several ways. It can handle document management, perform rapid legal research, analyze case law, and even draft initial legal documents, saving valuable time. For example, AI could quickly compile a list of relevant precedents, helping lawyers form case strategies more efficiently. By automating routine tasks, AI allows lawyers to concentrate on personalized client interactions, advocacy, and high-level analysis. AI tools can also provide lawyers with predictive analytics, estimating possible case outcomes based on data from similar cases, which can inform strategy and client consultations. In essence, AI in the legal profession enables lawyers to work more effectively and spend more time on their clients' unique needs. The result is a justice system that is both efficient and profoundly human-centered, as legal professionals are empowered to bring their full skill and empathy to bear in the pursuit of justice. The Eastern Caribbean Supreme Court has long exemplified resilience and adaptability, qualities that have enabled it to navigate an evolving legal landscape and embrace technological innovations to better serve the public. This adaptability is showcased in its progressive integration of technology and reforms aimed at modernizing justice delivery. Over the past decade, the court has implemented numerous transformative initiatives. One of the most significant advancements is the e-litigation portal, which has revolutionized the management of court documents and filings. This portal allows for electronic submissions, ensuring that legal processes are more streamlined and accessible. Litigants can file documents at any time, anywhere, breaking the constraints of traditional office hours and reducing delays, a testament to the court's commitment to procedural justice. The court's use of video link technology has also played a pivotal role, particularly during the COVID-19 pandemic. This innovation allowed the court to continue operations without compromising public safety, demonstrating the court's ability to adapt to unprecedented challenges. Remote hearings became not just a temporary solution, but a valuable tool for maintaining access to justice, reducing travel time, and increasing participation across the various jurisdictions it serves. The adoption of digital tools has extended beyond document management and hearings. The court's criminal module within the e-litigation portal, soon within 2 days to become operational in St. Kitts and Nevis, facilitates seamless case management from charge to sentencing. This has significantly reduced procedural delays in other territories and enhanced transparency and efficiency within the criminal justice system. Furthermore, initiatives such as the Model Family Court in Antigua and Barbuda illustrates the court's forward-thinking approach to specialized areas of law. This model court is designed to address sensitive family matters efficiently and compassionately, integrating modern procedural rules that support the well-being of children and families. These advancements reflect the court's deep-rooted capacity for growth and evolution. Such a tradition of resilience provides a strong foundation for the integration of AI and future innovations. The court's embrace of digital transformation signals its readiness to continue evolving and leveraging technology to ensure that justice remains accessible, fair, and adaptive to the needs of the people it serves. By building on these successes, the court can confidently embrace AI, knowing it is a natural extension of its tradition of innovation and resilience. The use of AI in justice, this picture is quite frightening, actually. That's why I use it for ethics. The use of AI in justice must be approached cautiously to avoid pitfalls such as bias, data inaccuracies, and privacy concerns. AI systems are only as impartial as the data they are trained on. Thus, it is crucial to monitor them to avoid perpetuating existing biases. Safeguards must include transparent protocols, continuous human oversight, and regular audits to maintain public trust. The court must set clear ethical guidelines to ensure that AI tools are used in a way that respects human rights and upholds the principles of fair justice. In concluding, I hope to have sparked reflection on what justice means for the Eastern Caribbean Supreme Court as we move into an era shaped by generative AI. We began with two questions. One, whether a court is a place or a service. And two, whether people truly need lawyers or simply resolution. I'll let each of you answer that question in your own minds. These questions challenge us to envision a justice system that, in its essence, transcends borders, tradition, and even the physical confines of the courtroom. Generative AI, as we've discussed, holds enormous potential to advance each pillar of justice. It can streamline procedures, aid judges in delivering fairer and more consistent sentences, provide early neutral evaluations that empower individuals, and support, not replace, our dedicated legal practitioners. The integration of AI can ensure that our courts not only meet current demands, but also adapt to evolving needs of the people we serve. This court has shown remarkable resilience and adaptability, as evidenced by the advancements like the e-litigation portal and expansion of the video link technology. My recommendation, Chief Justice, is simple yet forward-looking. A strategic 10-year plan to incorporate AI responsibly, focus on enhancing accessibility, affordability, and fairness in justice delivery. By developing court-driven AI tools, such as generative AI-powered early neutral evaluation system, the court could provide accessible guidance and streamline minor dispute resolutions, helping individuals navigate their options before stepping into a courtroom. As legal professionals, we are witnessing an unprecedented moment of disruption, yet one that invites opportunity rather than fear. This is our chance to reimagine justice as a truly accessible service, one that breaks free from the historical boundaries to serve people directly, efficiently, and equitably. In a sense, justice without borders is not just a theme, but a call to action. A reminder that justice should flow freely, reaching every corner of our region, transcending barriers and limitations. Let us rise to this challenge with openness, innovation, and a commitment to making justice a borderless reality for all. Honorable Chief Justice, with your leave, I'd like to end my lecture with a most apt quote from your predecessor, the most esteemed retired Chief Justice, Dame Janice Pereira, who in her final address on the opening of the law year 2024 had this to say, and I quote, "Make no mistake, AI is here to stay. What we at the Eastern Caribbean Supreme Court cannot do is ignore either the benefits or dangers of AI, which is developing at lightning speed and being integrated in every aspect of our daily lives," end quote. I can say no more than ditto Dame Janice. May it please you, Chief Justice, thank you all for listening and have a pleasant evening. Yes. Thank you. But wait, I said there was a surprise, right? Okay. I was checking to see who was paying attention. I have a surprise. I'm pleased to announce that St. Kitts and Nevis is the first country in the Western Hemisphere to integrate AI in government to provide law and legal and regulatory responses to the country's laws. Don't worry, I will explain what that means. The Ministry of Justice and Legal Affairs has partnered with a company in Trinidad called Chirami Limited to develop Voice It, our AI genius, built from generative AI, which improves user navigation and understanding of the laws of St. Kitts and Nevis. But it does more. Voice It will continue learning from all of the ministry's social media posts, new laws and amendments, and procedures and policies throughout the departments of the ministry. It will truly be your AI genius personal assistant for all you need to know about the laws of St. Kitts and Nevis and the operations of the Ministry of Justice and Legal Affairs. Here are a few features of Voice It. WhatsApp integration, easy to use and on everyone's phone. Website as a pop-up on the Law Commission's website, which I will show you an example of. Text-to-text real-time responses. Voice-to-voice capabilities. You can upload images and document attachments. It has direct references to the laws which it quotes to you, because the source documents are not the internet, but the laws that it was trained on. And people can download it directly. So I know there are a few skeptics in the room, so I just want to show you with a quick video, if it can be set up. This is the Law Commission website. This is Voice It. Voice It. What is the speed limit in Bastille? Send. Can you pause? Good. The speed limit within the limits of the town of Bastille is 20 miles per hour for all types of motor vehicles, including motor omnibuses, passenger trucks, motor lorries, and other motor vehicles except tractors. Tractors with or without trailers also have a speed limit of 20 miles per hour. Press play. But you can trust Voice It, but you also can verify. So you click, and it takes you to the part of the law that speaks to what you asked about. Pause. What is the penalty for not wearing, play? What wearing a seatbelt when driving? Question mark, send. The penalty for not wearing a seatbelt, pause, when driving is that a person commits an offense and is liable upon summary conviction, Magistrate Nisbet Brown, you're familiar with that, to a fine not exceeding $1,000. This applies to the driver and any passenger in the front seat of the vehicle who are not adequately restrained by a seatbelt. Play. Trust, but verify. It will take you to the section of the Act which it answered. What we have done is very shortly, we are hoping within days, right, PS? Within days, not weeks, and we will have a public launch so everybody can test it out. But now that you see how it is, okay, let me explain this. The Law Commission website is the website where you can search the laws. So it is integrated into the website where the laws are. But when you access the website from your phone and you click on Voice It, it brings up a WhatsApp conversation. So you can have a run-in conversation and ask Voice It our AI genius, whatever you would like. And we thought that it was important when the presentation was made to us for the rule of law, Prime Minister, and for our people's education and access to justice, for them to be able to have an easy, modern, generative AI tool to understand the laws of St. Kitts and Nevis more clearly. Thank you very much for listening.
Thank you, Honourable Attorney General. And in my opening remarks, I did say it would be thought-provoking, and that indeed was a thought-provoking address. And as we live in the age with Elon Musk and the introduction of robots, we have to embrace AI. And so I'm happy for this presentation, and I hope the students can see how you can embrace AI within our lives and within modern society. So I want to thank the Honourable Attorney General, and I can't wait to use Voice It. That's her name. I can't wait to use it. So now we get to the question and answer portion of the evening. And so a mic has been placed in the center. And this is for anyone at all who wishes to ask any questions to our featured speaker. Yes, about his presentation. And so you can approach the mic, and the Attorney General will be willing to answer any of your questions. Oh, Anderson, Henry, first up.
Thank you, Honourable Attorney General. Very thought-provoking. With reference to AI, have you given consideration to hallucination, and how do we protect ourselves from AI hallucination in decision-making?
You see, hallucination is more prevalent when it's a wide-based AI. If the court, for example, were to set up a generative AI early neutral evaluation app, it would actually have specific learning. So it wouldn't have it draws from the internet, but it's told, this is the information on which you give your decision or your advice. Similar to the Voice It. You actually train it with particular information rather than having like a chat GPT, which absorbs everything across the information. And then you end up with situations like the lawyer in New York who filed submissions with a case that did not exist. With actual AI tools and apps which are limited in scope. So you could say all English common law cases, all cases from the Eastern Caribbean Supreme Court, all the laws throughout the Eastern Caribbean, this is your data source. And then you reduce the hallucination which happens by streamlining the information you put in.
Thank you.
Yes. Okay, any other questions? Don't be shy, don't be afraid to approach the mic. Thank you, Mr. Ross.
We're not replacing you, King's Counsel. We're not replacing you.
Pardon me?
We're not replacing you, don't worry.
Replacing me. At my age, you could do it if you want to. What I would like to ask is, as far as this new thinking is concerned, what plans would you suggest that the Eastern Caribbean Supreme Court should have as it looks toward the CCJ on the one hand, as opposed to England?
Are you in the context of AI or generally?
Generally.
Yes, maybe we should ask Voice It. But King's Counsel, It's hard for me to answer that question because I'm a regionalist, and I believe in the CCJ. And at all the meetings that I've attended where we've had that discussion, I believe that we are more than capable in this region of having an apex court made up of our people. So I am biased.
You'll get no argument from me because I have always said that but for Chief Justice Warren being on the Supreme Court of the United States, the law would still have been Plessy versus Ferguson, as opposed to Brown versus the Board of Education, if you had to take it out of the country, where people are making decisions that affect you, and they can see it just from a long perspective. So I still come back and say, have you contemplated the position of the Eastern Caribbean Supreme Court in the long term? We've got all of the fancy stuff. We've seen computers come. Remember that when computers came on stream, we heard that it's going to be a paperless society. That didn't happen, but computers have been helpful. And I'm saying here, we've got AI, we've got all of these tools that can look internally. But as far as the big umbrella is concerned, where are we thinking?
Well, there will always have to be an apex court. I don't see, even with my research on AI, judges being eliminated completely. I think what it can do is at an early level, it can take matters out of the court because you can have an effective judge at a very early stage. But because I don't believe that the system that we have with an apex court will ever change, I don't see there being a long-term movement based on technological advancement away from that part of the traditional system which we follow now. I'm not so sure. I almost getting your question, but I'm not sure I'm getting it because you're saying, what do I recommend should be the long-term plan of the court when it comes to having to maneuver between having two apex courts?
No, not two apex courts, where your apex court is going to be either the CCJ or the Judicial Committee, and how does AI fit into that, recognizing that AI would assist at the trial level, and it could even assist at the appeal court level. But when we're moving up further to the policy section, which is where your apex court comes in, whether or not we are going to have an easy fit, and how do we recognize?
I see what you're saying. You're saying that effectively you would, yes, because technically there are some territories. St. Lucia is now with the CCJ.
Yes.
So if a St. Lucian court is bound by the decisions of the CCJ, not of the Privy Council, and AI would have to, no, you can train AI to actually think or know, you can train it to know that CCJ decisions are persuasive but not binding, and Privy Council decisions are binding. So it can be trained in that way so it doesn't hallucinate or get confused as to which is the authority it should align with.
Well,
It's that smart.
thank you very much, but there's one more thing I'm going to ask before I sit down. There's this guy in Canada, Marshall McLuhan, who coined the term that the media is the message. And recognizing that as far as government is concerned, you've got your legislature, you've got your executive, and you've got your judiciary. And again, looking back at what happened, I think it was the 2nd of April 2009, when in Guyana they passed a judicial judgments bill where the administrative aspect, the parliament, was crossing over and telling judges when they've got to file their judgments. We don't know what happened with that. But the one thing that concerns me is there was a substantial amount of criticism saying that here you've got the parliament crossing the line to determine what the judiciary should be doing. And against that, I am saying, why is it that the court is asking an aspect of government to tell us how the court should be running?
I certainly don't tell the Chief Justice how to run the court.
That is true.
But I can posit and advise and say that I recommend that for the administration of court, for the benefit of the people of the region, it should embrace technology. But I don't think there's any directives that come that blur that line for the separation.
I agree with you, Mr. Attorney General, and we could recognize that Chief Justice Byron, when he was at the court, was one pushing technology also.
Yes,
so technology hasn't hurt us.
It's helped us.
Thank you.
We recognize Justice Morley.
Thank you, Attorney General, for a really thought-provoking seminar. You've given us a great deal about why AI is going to be great. But I'd like you to tell us, if you can, why it might actually be a problem. I'm thinking that, firstly, it will probably generate a lot of lazy lawyers who simply press the buttons on their computer to create submissions, and I have started to see this. And then the second thing it may do is it may create drowning, which is where you can press buttons on your computer and create a 6 to 12-page argument on every legal point that springs to mind during the course of a case, and you simply drown your judge. And I've started to see that too. And then the third thing I'm curious about is whether it's going to create not fewer, but more litigants in person, who, when they work out how to use the tool, find any number of arguments, and they'll pile into court, and they'll be doing the drowning, so that you'll have submission after submission that you'll have to answer, and you'll be fighting against a motivated litigant in person who may not know all the rules, but you'll also be fighting against the entire internet working against you. So if you've got any other thoughts on what may go wrong, having given us an excellent exposition on how things may go right.
All I can say is all those are potential negatives to AI, what you've mentioned. To solve the first problem, I've seen it being done in US courts, where the judges actually say, make sure that your submissions are no more than 10 pages. So you can solve that initial length, throw everything against the wall, see what it sticks issue. You're going to get more litigants in person, because persons are going to feel empowered by the technology. That is something that the court is going to have to address. I don't know. I haven't put my mind to it. I try to focus on the positive, because I believe that human nature is such that we've overcome things that can be used in a bad way. Our genuine good nature has let us survive as a world, despite those bad things. So I really haven't addressed my mind to all of those potential negatives, but it's the yin and the yang of the world. With every good, there's a balance with it. But I think that it will, like other technologies, for example, with the internet, we've seen all the negatives of the internet. But I think there are more positives from it, and I think that's what AI will be as well. But the Chief Justice heard you, and when they get their actual advice, they will be able to deal with the potential negatives.
Okay. I see Ms. Malalu. Oh, and then we'll have the student. Yes. Or you let the student go first? Okay.
Okay, how can we ensure that AI systems used in the legal fields are trained to understand and respect different cultural and social contexts so that they make fair decisions? For example, in certain countries, religious beliefs are impact on the laws there. So how can we be sure that AI can understand that to make good decisions?
Very good question. that is actually the argument against the Privy Council. The argument against the Privy Council is that men and women sitting in London don't understand what it's like to live in Bastille and Castries. And the Privy Council has said, I read a decision yesterday or day before, talking about the local judges having a better understanding of the local circumstances, because justice is not just black and white, it is all the colors of the universe. And AI will just be like that. I don't necessarily know. That is why you will always need judges and lawyers, because there's nuance to life that I don't think AI will ever understand. So your question is very thought-provoking, because you cannot tell artificial intelligence, you can't teach it how to appreciate the drummers.
Yeah.
And to understand that what they did today is from our ancestral history in Africa, and what it means to us and the feeling we have when we hear the drums. You can't teach a system that. So it's going to be very difficult for the AI not to be black and white, meaning giving you that straight black and white answer or advice, and not taking into consideration the cultural elements of a society. So that's going to be very difficult to do. We don't know the extent of its possibilities. It could very well read all of the texts. It could read V.S. Naipaul and all of the other West Indian texts and kind of have an understanding of how our societies work, but it will never have that nuanced feeling that a judge will have when making a decision that involves something that deals with our culture. So it will never address all the issues, and that's why it will never replace judges permanently, but it can help make us more efficient.
Okay, thank you. And one more question. For AI isn't perfect. Nobody is perfect. So if an error was to occur because of AI, who would be held accountable?
That is a great question.
Great question. But there are lots of issues with AI. For example, there are intellectual property issues as well. So that's a question for a whole other conversation. We need to. I would need to consult with our IP director, and who they actually. I mean, the WIPO, World Intellectual Property Organization, is also thinking about those issues. I think that was a topic in the recent convention that the registrar attended. But that is a very good question, because it is nobody. It is nobody. If it defames you, who do you sue? If it makes a mistake, who do you sue? Because it is really just absorbing all of the information in black and white throughout the world. So I think that should be a paper you write in do you do sixth form law? You're in law?
Yes, I'm in law unit 2.
Okay,
My
good.
teacher is here.
Okay, well, your teacher?
Yes. Miss Leandra Edwards.
Leandra?
Yes.
Oh, that's
Yes.
Well, tell Leandra, Miss Edwards, that you all should do a paper on that. Liability issues with AI. And do the research and see and then make sure she shares it with me at the AGO.
Okay, thank you.
Okay, thank you. Hold on. Oh. We have another student. Okay, we'll have a student, and then Ms. Malalu, we'll have you. Yes.
Good night. AI, as you said, is technology, and technology can be hacked by a third party, whether it be, we grow up in the age of technology where 13s and 14-year-olds know to hack into very encrypted systems. Would there be steps in place to ensure that nobody, whether just having fun or with malicious intent, to hack into these systems and change any sort of law or system that would be misleading to an individual who's not a legal practitioner?
Okay, so I actually have thought about that one. So when I mentioned the potential ENE, Early Neutral Evaluation app, that could potentially be developed by the court, the only reason that people will trust it is because the capital of trust of the court will go with it. so that there's not bad information that is inputted. So if you create an app like that, it's going to have security mechanisms in place so that it doesn't do like what it did in New York with the lawyer, create a fake principle of law, even though I've seen lawyers do that before. But so it won't create a fake principle of law. And similar to the Voice It. We cannot, as I said, trust but verify. The Voice It mechanism has to be protected from outside hacks, because if you ask the question, what is the speed limit in Bastille, and a hacker has put in a fake motor vehicle registration act, and it gives you wrong information, that could be an issue. But like any other computer system, you have to prevent it and protect it from outside influence. The good thing about AI is that it even at this stage right now, because the ChatGPT 2, and right now is at 4.0, 4 plus. ChatGPT 2, which is old technology now, passed the New York bar, which is considered to be one of the hardest bar exams in the world. And that was exponentially reverse technology. So it's extremely smart, so you could actually potentially train it to shut down if there is an attempted hack of it. So there are ways you can do that by way of technology. I prefer the Minister of ICT to explain that, because I don't understand how that works from a nuanced perspective, but just from a general perspective, you have to treat it like any other technology and protect it from outside influence.
One more question. Just like anything that comes good to us, we tend to be over-reliant on it. Would there be policies in place to ensure, as the French gentleman said, that people don't come lazy and just anything the AI says, it goes, and just to speed up the process and get the money, just come over-reliant on AI itself?
So one of the conferences I went to, there was a presenter on AI from the Canadian central bank. And what they are doing, what the central banks are doing, are working on government policy when it comes to AI. So I'll give you an example. There's this thing that AI does called deep fakes. I don't know if anybody knows. This is where it can take videos of someone, like it could take the videos from the Chief Justice giving his speech today, and it could morph his mouth and let him say anything. So what they're doing with that is they're trying to establish a principle where there's like a watermark that verifies that the video is actually accurate. So if you do not see that watermark, it means that it's not verified, like it's a verified process. So the central banks around the world, from what she told us at that meeting, are rapidly trying to develop the policies to protect what you're discussing. Because we don't know what the bounds, I can't even imagine what the next election is going to be like because of this deep fake technology and all of those things, which have started, but are much easier to do because you, as a student, could probably pay $5 and get an app, and you could make a deep fake of the Chief Justice saying what you want him to say. And that's not a good thing. So there needs to be government policy in regard to that. And I know there's a push for law and policy to govern those sorts of ills, like what Justice Morley said, the negative side. But that's in progress, and I actually think we need to step that up and try to get ahead of the curve with that one too.
Okay, thank you.
Okay. Ms. Malalu?
Ms. Malalu, you use YouTube and TikTok?
Yes.
So
not TikTok, YouTube.
But so you knew what DIY meant?
No.
Do it yourself? You didn't? Okay.
Yeah. Yes. Good evening, all. With a worldwide problem of overcrowding in jails, especially in the Caribbean, and conditions being deplorable, and remand prisoners sometimes waiting 7 years before the matter comes to trial, and a general policy that a lot of us don't know, which is called the 23-hour policy in most prisons. This 23-hour policy says that a prisoner is entitled to 1 hour of fresh air. So when prisons are understaffed, it's much easier than to have 3 officers break up a fight to keep them locked up for 23 hours a day. And being locked up for 23 hours a day, if you can imagine, take a passenger bus, put some shelves in it, and put some sponges in the passage in between. And if there's no room left in the passage for a sponge, put your sponge under the bottom shelf. So we're looking at a situation similar to what we learned in history as to how our slaves were packed in a slave ship. And that is the reality in the Caribbean, 23 hours a day. Eat your meals in there, lie on your sponge, and get 1 hour of fresh air. If we're looking at technology, can we invest in technology to allow the remandees to go home and wait their 7 years and wear a bracelet and we monitor them with technology? Can we use technology as an alternative to a prison sentence where taxpayers have to feed, entertain, clothe, dentists for these prisoners? And if a family member is willing to support them, can they serve their sentence at home and their family pay for their meals if they have the financial support, that we're not looking at constitutional claims where I can't work, but yet you don't want to feed me? But they have the choice of deciding where, with the judge leeway, do you want to serve your sentence at home? Do you have the financial ability? Because if we're going to look at technology in those areas, let us look at technology with sentencing, because right now, our people are going crazy. Living in a passenger bus underneath a shelf. Thank you.
Noted, Magistrate Malalu. I can tell you that there was a commitment of all the governments in the Caribbean last October with the Needham Point Declaration on Criminal Justice Reform for that very purpose, to ensure that there's swifter justice. And there's actually a webinar this Thursday, which I think you should listen to. It's going to be on UETV, where there's going to be a progress report a year later as to where the Caribbean territories are with criminal justice reform. But the reform you're speaking about is less technology-based, but more creative ways of punishment. And that is something I can tell you that the DPP is very keen on, and we're discussing internally some creative laws, different types of laws that we might bring to the cabinet for determination if we should take it to Parliament. So I'll have a separate discussion with you about that, but it's a serious problem throughout the Caribbean, and we're trying to address it in St. Kitts and Nevis.
Mr. Eibel, and I would like to alert, this will be our final question. If you do have any other questions, okay, we'll oblige the minister. But if you do have any other questions, students, after, in our cocktail, you can approach the Attorney General or the Chief Justice. Thank you.
Good evening, everyone. Attorney General, in my mind, I'm a bit confused. When the young lady asks, who is responsible for justice? No. And you said, if they made a mistake, yeah, and who's responsible? AI would become, in my mind, a part of the justice system. It is not acting on its own if it is a tool of the government, per se. You know? So it's not acting on its own if the court system is implementing it and using it. Then AI becomes your responsibility And so you will be sued, the government will be sued. And so if a mistake is made because something is implemented by the court for the benefit of lawyers and everyone else, etc., it must have someone responsible. A police officer is not independent. He's part of the Department of Police and the government and so forth. So if he make a mistake, he gets sued, on the government's behalf, he gets sued. So I think maybe AI just get thrown under the bus somehow there, because somebody is responsible for that.
Yeah, if there's a specific tool that is developed, like for example, if the court develops an app, potentially there could be liability, but the court is going to put all the waivers in it that's saying, this is what it is. For example, when you go and voice it and it gives you a response, it says this is not a substitute for legal advice.
Yes, you have to have a waiver.
So, it has a restriction on it.
Yes. Okay, Minister, we'll oblige you in the last question. And this is our Minister of ICT, so I would allow him to ask the final question.
All right, thank you, Ms. Bradford Mack, and pleasant evening to everyone. AG, excellent presentation. We are saying among ourselves how very proud we are of you in the cabinet. I just wanted to perhaps take an opportunity to just respond to one of the questions that was asked.
Yes. All right, thank you so much. And we are at the part of the evening where we wish to thank again the Honourable Attorney General for his presentation and taking the questions. I think they were all well-founded questions. And of course, he'll be available after. We wish to invite again Ms. Azaria Amrit to assist us in presenting to the Attorney General a gift to thank him for today and for the address, the thought-provoking address that he's delivered. So on behalf of His Lordship, the Chief Justice and the Eastern Caribbean Supreme Court, we wish to present you with this gift. Okay. Photos. You have to go for the photos. Come up this side. This side. Yes, yes. And we ask that you open it, Honourable Attorney General, even though that's not, but for you to see it. Open it, yes. It's something that you can share.
Can AI open it now?
Yes. Yes.
Very nice.
Yes.
Thank you very much.
Yes, something we can appreciate.
Mr. Chief Justice?
Yes, Chief Justice, it would be good to get a photo, yes. Come, go this, let them come on this side. I'll do it.
I don't know.
Go on that side. Go a little to the...
Well, Chief Justice should be there.
Okay, thank you. And now we wish to invite Mr. Hassani MacDonald, a member of the Bar of St. Kitts and Nevis, to deliver the vote of thanks.
Madam Chairperson, please allow me to adopt the protocol that was ably established. It is my privilege to extend a heartfelt vote of thanks to all of those who would have contributed to the success of this evening's ECSC lecture series. First, let me express our deepest gratitude to His Lordship, the Honourable Mr. Mario Mitchell, Chief Justice Acting, for his insightful remarks and unwavering leadership in the Eastern Caribbean Supreme Court. Your dedication to justice and the rule of law continues to inspire us all. A special thank you to the Honourable Dr. Terence Michael Drew, Prime Minister of St. Kitts and Nevis, for his warm and gracious welcome. Your presence here demonstrates the government's commitment to fostering legal excellence and public discourse. We are especially grateful to our keynote speaker, the Honourable Senator Garth Wilkin, Attorney General and Minister of Justice and Legal Affairs. Your keynote address was both thought-provoking and inspiring, providing a wealth of insight into the critical issues facing our justice legal system. We were challenged to embrace artificial intelligence as a transformative tool within our legal landscape, and you underscored how AI can enhance efficiency, improve access to justice, and modernize our legal systems, all while ensuring they remain relevant in this rapidly evolving digital age. Our sincere thanks goes to Ms. Nerissa Williams, Permanent Secretary in the Ministry of Justice and Legal Affairs, for your continued support and dedication. To the dedicated staff of the Eastern Caribbean Supreme Court, particularly Mrs. John Theobald, Chief Registrar, and Mr. Brissett, Damian Brissett, we are grateful for your hard work behind the scenes. A special mention goes out to the team at the St. Kitts Marriott Resort, led by Mistress Hadia Mills and Mr. Andrew Cleary, for their exceptional service and ensuring that tonight's event ran seamlessly. We extend our appreciation to the Ministry of Education, as well as the students from the Clarence Fitzroy Bryant College and the Nevis Sixth Form College for their active participation this evening. Your engagement add a vital perspective to our discussion. Our thanks also go out to Chameleon Media, our media partners, UATV and SKNIS, for ensuring that this event reaches a wider audience, including our online viewers. To Mr. Vincent Perkins, we extend a special thank you for your support in this venture. To the Brotherhood Drummers, thank you for your captivating cultural presentation. Your performance added vibrance and energy to this evening's proceedings. We also acknowledge the dedicated staff of the High Court Registry, Ms. Loretta Evelyn and her protocol team, and all the service providers who contributed to making tonight possible. Finally, we thank you, our audience, both here in person and online, for your time, engagement, and thoughtful participation in the question and answer session. Let us continue to collaborate and build on the ideas shared tonight as we strive for a more equitable and just society. Thank you and have a wonderful evening.
Okay, and I would like to extend my very much thanks to everyone for coming out this evening. I know it's getting a little late, and some of you, this is past our bedtimes, but thank you for staying and enjoying this, this experience. And so we wish for everyone to get home safely, to travel home safely, and we thank you. And we welcome you to partake in the cocktail outside and have some continued discussions as well. We'll now stand for the Governor General to leave, her late Dame Marcella Liburd, who will be followed by the Honourable Prime Minister, Dr. Terence Drew, and will also be followed by the departure of His Lordship and the Honourable Attorney General. Yeah. Okay, all right. Thanks to everyone, and we can now enjoy the cocktail.